Good morning, members of the jury. I wanted to talk to you about what we've learned YSL is about. And 4 words come to mind. The first word, deception, intimidation, destruction, and death. Deception of the youth who get enamored with what is presented publicly and then deceived when they become a part of the criminal enterprise. Deception for law enforcement to not uncover the actions that they commit, and deception in this very courtroom with witnesses that have sat right before you to try to continue that enterprise. Intimidation, the public videos we've seen about people that they label as rats, people that they label as snitches or snitching, and that repeated threat, either overt, out in the open, or subtle, that if we do a crime to you or you know about it, don't say anything. The destruction has multiple parts. You've heard from multiple communities all throughout Fulton County that often similar pockets in the city have been affected, from dealing of drugs, the robberies, the shootings, the shell casings, the windows, the doors, the refrigerators, the cars, over and over. That's the destruction. And then you've heard about the death. Jeffrey Williams himself said, YSL, in this video after he says murder gang, someone right next to him says YSL till we're dead and pale. But also, you've heard about 3 murders, Donovan Thomas, Chanel Drinks, and Jamari Holmes. That is what YSL, the criminal enterprise, is about. Now, I'm going to talk to you about count 1 RICO and criminal street gang. And so when I am complete, at the end, Ms. Hylton will come up and talk to you about the murder of Donovan Thomas and the murder of Chanel Drinks and the remaining counts. Now, what I just said is not just my words. This is the deception, intimidation, destruction, and death that I just spoke to you about. Murder gang in my slime is above the law. But in Fulton County, nobody is above the law, and that's why you're here.
Y'all already know why I said we dead and pale, bitch.
Murder gang, bitch.
Yeah.
Slick. Gang. No cap. No cap. And we actually free. You know that. Niggas always free.
Those are their own words, murder gang. What they are publicly stating that the enterprise and the street gang, and I may use both of those terms interchangeably today, are about.
I don't think y'all niggas got more than us is dead now.
This in your video?
There's a we and a us. He's saying the only thing that they have is more people who are deceased, which is saying that we don't. And the they, I argue from the evidence we've been presented amply throughout this trial, is their rivals, their ops. The Atlanta Blood Gang, 5th Gang, 9 Dudes, YFN, that group. And lastly, after publicly bragging and boasting about murders, what is their viewpoint on being held accountable? Well, let me take their own words. Don't just take mine.
Just beat a murderer. Pay my lawyer 30 for that. Pay my slimes above the law. Ain't arguing no credit.
That's saying my slimes are above the law. So now I'm going to equip you with the duty as jurors so that you can learn about the law that the judge will instruct you on, so that you can have the toolkits needed to deliberate and understand how to organize the evidence that we have presented. So that's what I'm going to here to do with you today. So I'm going to take a step back. In general, jurors' duties, it's to honestly seek the truth. You've heard evidence, testimony, physical items. It's not to seek doubt, it's to seek the truth. You determine, how you handle and weigh the evidence. And I'm going to highlight some things for you so that you can understand some connections between some of these evidence. Because there's connections between these shootings, connections between these crimes, locations, victims, and accomplices that's important for count 1 RICO. And that's what I'm going to walk through with you about right now. The duty to deliberate. When all of this is done, all of y'all will go back there and speak with one another. Speak freely with one another. Go through the evidence and talk about what you've heard throughout this trial and talk with fellow jurors about the evidence as you reach your verdict. And like I said, seek the truth. Now, I'm going to explain to you in a couple minutes about what you can and can't consider. So everything outside of this circle has comes up in almost every trial, sometimes a little, sometimes a lot. Sympathy for victims or defendants. Viewpoints on a witness. You like the witness, you don't like the witness. You like the police, you don't like the police. You think about some issue that comes up in a case that's not about the evidence and the law. You disagree with the law. All of those things you can't consider. What you can consider, and it's going to populate in the middle, is the evidence, the testimony, the physical items, the videos, the wiretaps, the jail calls, all of those things you can consider at this trial. And it's not lost on me the length of this trial. And I can stand up here for 4 hours and explain to you my genuine understanding and frustration with how long you all and the sacrifices you've made. And what I thought about, because when you initially came on, it was 6 to 9 months, and now we're here 12 months later, and that is a significant difference. And there's one time in my life that came to mind about this. I couldn't do this again today, but I ran one marathon. When I got there that day, I was supposed to do a half marathon, just many years ago. And when I'm in line with one of my best friends who encouraged me to run, I see people much older than me. I won't call them old, but they may have been pushing 90, marathon. And so he gave me that look, and I said, all right, I'll do the marathon with you. And during that, expecting to run a half, that day running a full, I had moments where I wanted to quit. I had moments I wanted to walk. I had moments where I wasn't ready, I wasn't prepared, I didn't sign up for this, even though technically I agreed to the marathon. And as I got to the end, like we are here, I said, if I walk off on mile 21 or 20, all of this will be for nothing, and I will regret that. So with this time, I ask you to see it through, finish strong, and by that I mean listen to the closing arguments and deliberate with one another in the evidence, because you owe it to yourself, you owe it to the victims, and you owe it to your duty as jurors. And like I said, what I wanted to do, because I can't go back and change the hands of time, I can't, is make this time valuable and give you the tools you need. Because you've heard a lot about RICO, but you've not yet had anyone explain what that means. So that's my goal, and that's what I'm here to do, is to help that you can understand the law, how it fits with this evidence, so that you can deliberate and reach the only reasonable conclusion that these defendants and these co-conspirators are guilty of count 1, conspiring to commit RICO. So I'm going to walk through that with you. Now this circle, I speak faster than I click, so it's going to catch up with me. But like I said, you consider the evidence, the testimony, you don't consider what is outside. Now, burden of proof. The state has always had the burden of proof, to prove beyond a reasonable doubt. And that's a burden that I own. It's how it should be. And so the state, this burden of proof rests with it until we prove each and every element beyond a reasonable doubt. What is a reasonable doubt? Everyone's heard that term, but what does it actually mean? It's not a mathematical certainty. There's no algorithm or specific number. It is a doubt that's reasonable. It's not vague. And so this presumption, I use a cloak, right, where you're presumed innocent. Everyone is. Until the state has proven your guilt on whatever crime, in this case, RICO, murder, street gang, beyond a reasonable doubt. For some of y'all, when you're back here deliberating and thinking through the evidence, you may have realized halfway through my speech today, when you understand RICO, that they're guilty. You might have come to that conclusion months ago. You may have come to that conclusion in terms of where we are in the evidence as you walk through it, at a different point. But when the state proves, as we have beyond a reasonable doubt, that cloak of innocence goes away. And that's what you as jurors are here to decide. And reasonable doubt, like I said, it's reasonable. You don't seek doubt, you seek the truth, and it's a doubt. It means just what it says. If I were to I wouldn't do this, but if I took some from Madam Court Reporter, say her coffee pot, and there's a security camera right there, if all of y'all saw me do this, if I had a trial and never called one of y'all out, I'm on trial for stealing Madam Court Reporter's coffee mug, if you didn't, if you had a trial with just that surveillance video, and it clearly showed me unmasked, take it and leave, you wouldn't need all these witnesses. Or if you had the reverse, you didn't have a surveillance video, but you had an eyewitness or circumstantial evidence. Just because you don't have a piece of item or evidence doesn't necessarily mean reasonable doubt. It means just what it says. Is it reasonable? So I'm going to show you an illustration that is something we all recognize, which is a dollar bill. And you're going to see pieces of this dollar bill missing, and all of you will immediately recognize what it is. And like I said, it's not a mathematical certainty. It is reasonable doubt. That's the dollar bill, right? If you have pieces of the puzzle, and some of y'all may like puzzles, that are removed, everyone knows that that's a $1 bill. There's no reasonable doubt that that is a $1 bill, even though almost 50% of it is gone. That's just a visual illustration to prove the point. Direct and circumstantial evidence. So direct evidence, physical items, it's what's said in this witness box before you, personal observations, that's all direct evidence. Circumstantial evidence can be cell phone records, where people are within a general radius, ankle monitor data, what someone's actions afterwards, who's calling who, who's texting who. That can circumstantially prove and lead to a conclusion. Whereas, and you can use both. The law doesn't weigh direct or circumstantial more or less than the other. And then in trial, you're going to use both. And you always have your common sense, which you always have brought with you each day and can use when you deliberate to make reasonable deductions from both direct and circumstantial. They play off one another. Like I said, these are all direct evidence. Just think what you saw, what you heard. If you were to physically touch a firearm or a shell casing, that would be tangible evidence. That's all direct. A good example for circumstantial is, imagine once a week, twice a week, you all go and pull and pump gas. You pull up to the pump, you know your car has the E, it's flashing red. You go, you put your credit card in, or you walk inside, you come out and you start pumping gas. And then when you leave, when you put your credit card in, you hear it kind of click loudly, you know it's done, you put it back in, and you drive off, and all of a sudden what was on E is now on full, right? You never saw the gas go inside, but you know, circumstantially, that your car tank is full. That's a classic example of, you may smell gas, but you never actually see it. You could, but most of the time you don't. That's circumstantial evidence. It can be quite strong, like in that example. So it doesn't have any more or less weight than any other piece of evidence. Testimony of a single witness, if believed, is enough to establish a fact. Take Tarabia Hill, Act 61, the armed robbery that Christian Eppinger did with YSL on his face, unmasked. If you believe, then I can't vouch or tell you the credibility of the witness. That's for y'all to determine. So if you believed her testimony, that's who robbed me, this is what he took, and then he drove off, a testimony of a single witness is enough to establish a fact. In that case, with her testimony, it would be every fact of armed robbery. So that's one example of a single witness can establish. Sometimes it's only one fact. Where is someone? Where is someone not? But in that case, that testimony would be enough to establish the elements. So keep that in mind, because testimony is important. Like I said, you determine credibility. So you got to ask yourself, why did certain people testify how they did when they said this? Now, I'll argue you think about what people said before they were indicted, before their friends were indicted, before sitting in a courtroom with you and people that they know well. What do people say when no one's looking? On a wiretap, on a jail call. That, to me, is quite illuminating of how they really feel or think. Think about why people would testify how they did. Why people would either genuinely not remember or act like they don't remember. I'm sure all of y'all remember quite well my kind of long back and forth with the gentleman, D'Angelo White, right? Where we played a 911 call where he says this is D'Angelo White. He wouldn't even acknowledge that, and it was a lot of back and forth. Why would he not come in here and testify about his friend, Dexter Montgomery, getting half of his head shot off when he was a kid? And he called 911. Why? You determine that. Now, I have reasons I'll explain to you why, but think about that. You can use common sense. Y'all been sitting right here, and there's a reason you're closest to the jury box, because y'all are the determiners of credibility. And y'all know and can think of examples as I'm talking right now throughout this trial that you've seen of that. Who doesn't have an interest, right? If you have some, I'll use, someone from the Georgia Bureau of Investigation, right? They come in, they test an item. They don't usually know the defendant. They don't know the case. They're just doing their job. They don't have, in my opinion, any stake in one outcome or the other. They don't know. A random citizen, or Doug Bailey talked about the ankle monitor data. He's just reading the data. Those kind of witnesses, I argue to you, can be quite credible because they don't have anything to gain. They have nothing to lose. Think about people who do and how that would have impacted their testimony. Their opportunity for knowing facts. If someone hangs out with one another, like Mary Zachary, you saw all these photographs in 2015. He's in photo after photo with Shannon Stillwell, Monte Kendrick, Mikion Garlington. If someone interacts daily with someone, it's probably reasonable that he would know what they're up to, that they would confide in him. Versus if you had someone who only hung out with somebody one time, probably wouldn't be reasonable they'd know all their deepest, darkest secrets. That's just common sense, but things to think about. Now, I'm going to give you an example.
So, nigga, a lot of they mama, a lot of they kids, a lot of they brothers and sisters didn't get ready in the courtroom and tell the God honest truth.
Fuck, nigga.
Don't get it.
Y'all
Y'all nigga need to get fucking killed, bro.
You snitching bitches.
From me and YSL.
That's what's said outside of the courtroom. These are all witnesses who testified that were either co-conspirators or indicted on this case. And ask yourself, you could know it just as well as I right before if the state would ask, is YSL a gang? The words music group, you know it's about to come off, or I've never heard of that. I said gang, G-A-N-E. I didn't say G-A-N-G, even though you just heard them say gang. Think about that and why people would come in here and think about what they said. I mean, when Darius Zachary said that these two defendants confessed to him to murdering Donovan Thomas the night of the murder, you don't think he's going to come in here and back up off that? Think about Mooney Lee, the bragging or boasting about the murder. We put that on your tombstone. The things he knows when he's sitting up here don't sound good in a trial of his friends, fellow gang members, and co-conspirators, so he's going to back up off of them. Think about Walter Murphy, Antonio Sledge. When he did his plea agreement, said that he had knowledge that someone was involved with the murder of Donovan Thomas, but then backs up off of it, right? He gives why. Think about why. And think about, they know the feelings that these defendants have about people who come in and tell on them.